there's been a lot of talk about the need for an FBI investigation. There are many of us who wish that that's where this would have begun, as it should have begun, as it could have begun had these letters been handed over to the FBI. Well, let's talk for a minute about what would have happened had that occurred. Well, they would have gone to Dr. Ford, and they would have interviewed her, and they would have prepared a report outlining Dr. Ford's allegations. That report would have reflected more or less what we heard yesterday, probably a more distilled version of that, similar to what we saw in her written statements before she appeared before this committee. They would have gone to Judge Kavanaugh. They would have interviewed Judge Kavanaugh. And Judge Kavanaugh would have told us then, as he told us yesterday, that no such event ever occurred, that he never did this to any woman, not in high school, not in college, not before, not after. They would have gone to the other alleged eyewitnesses to this event, including Mark Judge, Patrick Smith, and Leland Kaiser. They would have taken statements from each of them, and those statements would have indicated, as they have each indicated in written statements submitted to this committee, that they recall no such event ever occurring. And so we have investigated. I too wish it had been investigated by the FBI, and had it been investigated by the FBI at the outset, as it could have been, as it should have been, as it would have been when these letters were received, then this could have been handled in a much more dignified manner, in a manner much more respectful to Dr. Ford, in a manner much more respectful to Judge Kavanaugh, and respectful to both of their families and indeed this entire process. Now, some have mentioned today that there was some emotion in the room yesterday. Yes, certainly. These are emotional circumstances. My heart goes out to both Dr. Ford and her family and Judge Kavanaugh and his family. They've both been through a lot. I don't blame either one of them for demonstrating some emotion, not for a moment. In the case of Dr. Ford, clearly she's been through something awful. In the case of Judge Kavanaugh, he in recent days has seen, in addition to this allegation, dragging his name into the public record, he's seen his name dragged through the mud on a lot of other things, including an allegation that he was involved in and, in effect, running a drug distribution and gang rape ring. Now ask yourself the question, if you or someone you love was alleged to have been involved in running something like that, might not you feel a little bit emotional as well? And might not that spill out into your testimony if you were called in front of this committee? Look, we have a job to do here today. Our job yesterday was to hear from Dr. Ford and to hear from Judge Kavanaugh. We've done that. Our job now is to vote. Today, we're going to do that. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. I said at the first day of the first hearing regarding Judge Kavanaugh that this is not normal. It might look normal. You have the nominee, you have the family behind them, you have all the cameras on, but it wasn't normal. It wasn't normal because this nominee was handpicked by a president who, in just the last week, has gone after his attorney general, threatened to fire the deputy attorney general who's overseeing a major investigation, a national security investigation, handpicked by a president who's constantly undermining law enforcement, constantly undermining the FBI. And yet, this president picked a nominee who has the most expansive view of executive power that we've seen. A president, a view of executive power that, according to his writings and even the case law, says, in his own words, in an opinion, that a president should be able to declare laws unconstitutional. In his own views in legal writings, that a president should be able to be immune from investigation while sitting in office, that we shouldn't have a special counsel statute. So that's where we start. That's the core here as we look at the constitutional issues that we're facing. The second reason this isn't normal is that we did not get the information we needed to make a decision. I come from a state that believes in process. In my old job for 8 years, I headed up the Hennepin County Attorney's Office. We handled, by the way, 12,000 juvenile cases every single year. So I saw cases just like the one we heard about yesterday. But in our role, I would always tell people if we had to let a case go, if we had to make a deal that people didn't like, our role was to be ministers of justice. It was to convict the guilty, but also protecting the innocent. And I don't think we protected the innocent very well yesterday, and I certainly don't think that we're doing it today. There was a lot of chest beating that went on yesterday on the other side. And it was pretty effective, I guess, if the goal was to distract the American public for what they had heard in the morning, to distract and deflect from the moving, powerful testimony we heard. And I don't want to hear about respecting Dr. Ford when we are not giving her the respect of having an investigation of the case that she made to us yesterday. It was a while ago that this happened, and there's other claims out there as well. But it's been my experience, as Senator Whitehouse just articulated, that if you don't go back and look at things and you don't look at corroborating evidence and you don't talk to the witnesses, you're never going to know what happened. I have proposed and talked to some of my colleagues, and I know others have as well, as a finite period for an FBI investigation, maybe a week. George H.W. Bush ordered that in the Anita Hill case, a 3-day investigation. That happened. Whether the respect of having that investigation, and that is wrong. That is not being ministered. This was a woman with no political background who made an attempt to call the front office of her congresswoman. That's what she did. She did this before the nominee was even picked. She did it when the nominee was on a short list because she was concerned. That's what she did. So don't argue that she is part of some massive political strategy. Those aren't the facts. And yes, it's messy. The justice system is messy. Things come in at the last minute. It happens all the time. It happens before a trial. It happens before a hearing. And the question is not if it's messy. Senator Flake himself said yesterday, this is not a good process, but it's all we've got. The question is, what do you do when it happens, when you're in a position of power? What do you do when it happens? You may not like how this came in at the last minute. I would have liked to known about it earlier too, but I didn't. The question is, what do you do when it happens? And when it happens, you don't just put it under the rug. For so many years, this is what happened to claims like this. They were just swept under the rug. What happened in the House, no matter how bad it was, didn't belong in the courthouse. And that hurt women and that hurt children for a long, long time. But the times are changing now. We have someone who made a credible claim. The chairman even thanked her for her bravery. Well, where is the bravery in this room? This rush, when in fact we could have a finite period of time to interview a finite period of witnesses. Someone who she alleges was in the very room where it happened. We are not able to even cross-examine them, ask them questions. We're not allowing the FBI to go in there and tell him to his face that you're going to get in criminal trouble if you don't answer these questions correctly. Instead, we get a letter behind the veil of a law firm. That's not the same thing. We have a polygraph expert. Yesterday, I put that polygraph exam on the record. People were bristling over there and said, well, we want to see the charts. Well, we would be happy to have the polygraph expert testify and explain how this was verified. And yes, as Judge Kavanaugh pointed out, this is not a test that is admissible in court. But guess what? We use it for job interviews. We use it for the FBI. We use it for the Defense Department. We use it for the CIA. And the nominee himself has even said that this is useful to use for those purposes in a case that he decided in 2016. Those are the kind of witnesses we could hear from if we had the opportunity, maybe 1 week, to do it. So I look at it this way. If we want to show Dr. Ford respect, we give her the respect of having her case heard and the evidence looked at. I look at it as, what are you hiding? What would it hurt? If Judge Kavanaugh is so sure that he has this corroborating evidence and what this calendar means and what these things mean, then what is he afraid of if we just spend 1 week looking at the evidence? What I have heard today just adds to this. When I heard this sanctimonious talk about some kind of a political strategy, well, I'll give you Exhibit A, Merrick Garland, who was delayed for nearly 10 months. You talk about a nominee getting off the floor when all we're asking for is 1 week for an investigation, and you kept Merrick Garland away from this committee for 10 months? That's not even a comparison. That was a strategy yesterday, and boy, was it a strategy. And I sure hope that some of the senators who have not yet made a decision, who are not on this committee, will look at the evidence and look at what happened and see it for the strategy that it was. I asked Dr. Ford yesterday about what she remembers from that night. And I also asked her what she couldn't forget. And here's what she said. The stairwell, the living room, the bedroom, the bed on the right side of the room, the bathroom in close proximity, the laughter, the uproarious laughter, the multiple attempts to escape, and the final ability to do so. We heard her talk about how she had a civic duty to bring this up. We heard her testify about how she had actually brought this up 6 years before to a counselor, about how her husband recalls her using the judge's name. In the rules of evidence, it says that statements made to a professional, to a medical professional, are considered to be credible. In cases, when you compare evidence, you look at what their goals are. What would be their reasons to lie? And I look at, you have on one hand a judge who is a career-making moment to get on the United States Supreme Court. And by the way, no one is entitled to be on the United States Supreme Court. And then you have a woman who tried to keep this confidential, who came forward, sent a letter, tried to do what she could to keep her name out of the news, and finally, when the reporters showed up at her door, she came forward. I just see these as different. And when you look at the rules of evidence, when you look at credibility, the fact that she had mentioned this years before means a lot. But you could have doubters. I understand that. But when we don't have an investigation and we don't have things in writing to be able to look at the facts, where are we? I have been on this committee for a number of years, and I have been briefed on FBI background checks. And a number of times, and my colleagues know this, nominees withdraw because of what is in those background checks. They pull their names out. The press never knows it, but it happens. Or sometimes we're presented with some information that's not public, and we have to make a decision. Well, does this drug use amount to something that should keep this person off the bench? Does looking at this website amount to keeping this person off the bench? These are things we've actually considered. That's the kind of information we get from those background checks. And I think it's a good thing because not everyone needs to be dragged through the mud. Things are contained in a background check.
May we have order?
Those background checks are useful for us and they're useful for the American people. I, for one, don't want to live in an evidence-free zone. We need this information. I would submit to my friends across the aisle that this is not a he said, she said. This is a he said, they said. There are a number of people out there who have talked about the fact, including the nominee's roommate, that he is belligerent when he gets drunk. Yes, that was a long time ago. Maybe he doesn't do that anymore. And I know people in high school drink a lot and in college, but when I asked him about this to try to get to the facts, I'm not an FBI agent, but all I was trying to do was try to figure out, well, maybe he is partially.
Great pleasure in welcoming the Prime Minister of Malaysia, His Excellency Mahathir bin Mohamad,